Sorry, my lord. My lord, I'm sorry.
I'm sorry, Mr. Solicitor. We are in charge. We will be here, Mr.
I have
I'm
to
sorry,
open
my lord.
my
Kindly
case.
last minute, my lord. Last.
Mr. Solicitor will hear you later.
Yes.
Yes, Mr.
My
Roy.
lord,
Now,
only a minute, my lord. Only a minute.
No.
My lord, your lordships may give me a minute.
Dictate to us how we will conduct the proceedings.
No. I'm not, my lord. I am
I'm not
earnestly
allowed that
requesting.
in my court.
My lord, I am earnestly request. I would never do that. Your lordship knows, my lord.
Yes.
My lord, this is a matter, my lord, too sensitive an issue,
Of course,
where, my lord,
yeah.
your lordships would examine the preliminary submissions and, my lord, then give me some time. We may have to consider what would be the stand of the government,
Sir.
my lord, in further participation in this debate.
So trust us to have a broader perspective of everything.
My lord, I fully trust, my lord. There is no question
Therefore,
of lack of trust.
we want to understand from them what they want to argue.
My lord, then, my lord, your lordships may give me time, my lord, to consider to what extent the government would like to participate in this.
Anything but adjournment. And I think anything but an adjournment.
No, I understand, my lord, your lordship's anxiety, my lord, I understand. I share that.
Solicitor, are you saying that you don't want to participate? No,
I am only saying,
participate. It's a prerogative you have.
my lord, I'll not go that far, my lord.
No, Mr. Solicitor, that let me say that. It look nice when you say that we will see whether we participate or not.
No, my lord, I'll take instructions. I didn't say I'll not participate.
Instructions are here. When
My lord, the instructions on the question whether which forum should debate and discuss this subject.
It's a very important situation itself. That's the main this thing. Whether the court can go into it or whether only Parliament will legislation issue like this.
My lord, your lordships would examine. My lord, kindly give me 2 more minutes. My lord, this is not an issue which can be debated, my lord, by 5 individuals very learned on that side, 5 individuals on this side, 5 very brilliant minds on the court, no doubt about it. None of us knows what are the views of, my lord, a farmer in South India, a businessman in, my lord, Northeast. My lord, these will have to be, my lord, this will have social and other ramifications. My lord.
Yes, of course. We'll consider that. We'll certainly have that in
My lord,
mind.
your lordships, I'm sure would consider the request. Only request is kindly consider that first.
No, we'll allow them to open the case so that we have
My lord,
an
then your
idea on
lordship,
what they
may,
are.
my lord, rule on that. That's my prayer, my lord.
May
That's
I
my
submit,
prayer.
my lord?
Yes.
A short preface first.
Statement of state, my lord,
Yes.
on behalf of state of Madhya Pradesh, which your lordship was kind enough to direct it.
Sir, we'll hear you. There's no
It is
difference.
not
Your
for
lordship may hear any
intervention, my lord.
state. We have no objection. Your lordship may hear any state.
No, not
Just as a
intervention.
preface,
No, you should have
everything
joined
which the
every
solicitor
state
has
as a-
said does not, my lord, hinge on maintainability of a petition under 32 by an individual who complains that his fundamental rights are being restricted in some form. I have a right to approach this court. This will be a defense whether your lordship will leave it to the legislative forum or the courts forum. There is no question of saying, my lord, that I should answer that first. I will open my case. They will raise a defense. Please don't touch it. Throw it away. Your lordship do it all the time. Matter of executive policy, we won't touch it. He will say whatever he has to say. But I have a right to file a 32. I have a right to be heard. My grievance may be right, may be wrong. Your lordship will deal with it. And your lordship will deal with their responses about, my lord, this, that, or the other. When it comes, it's not a case of 7-11. That, my lord, a suit is barred by operation of law. That is a preliminary objection. This can't be a preliminary objection that your 32 is there, but the impact of 32 will be this or that.
No, it's
That
maintainability.
impact can
These
never
are
be a part
preliminary objections.
of a preliminary objection. That be a defense. That don't touch it. This is too overbroad. This, that. They will say all that, my lord. So now, my lord, let me open my case.
Yes.
Well, only one aspect, my lord, and
Please now.
Yes.
ultimately it's the lordship's prerogative. But I should not, my lord, be, my lord, told after, my lord, generations after generation, we did not bring this to your lordship's notice. In Special Marriage Act as well as in Hindu Marriage Act, every state have separate rules.
Please.
That makes more, my lord, case for calling all the states and hearing them. Your lordships have, my lord, partial view from both sides.
Only one.
He is very clear about his view. I may be very clear about my view. But none of us represents views of the nation. That's my preliminary objective.
My lord, the Solicitor General is aware of all the persons that we are talking of fundamental rights. Fundamental rights, by their very nature, are a limitation on the legislative power of the state. Your lordship need not defer to
I'm
Parliament.
not for a second saying
If it is a fundamental right, my
not
lord,
there.
and if it
Who
is,
should protect the fundamental
if it is
rights?
a
Whether by
status-
parliamentary law?
All right. What
Lord,
we do is,
can
fair
start,
enough.
my lord, if it is a status confined to,
We'd like
Let me
to
open my case.
Yes. You can tell us.
Yes, let me open my
What
case.
is the canvas of the case?
So, my lord, in a very, very narrow conspectors. My lord, we are persons, my lord, who are of the same sex. We have, my lord, according to us, the same rights under the Constitution as the heterosexual group of the society. Your lordships have held so. I don't need to reinvent the wheel. That we have exactly the same rights as our brethren of the heterosexual group of society, which is the majority. We are a minority. The only stumbling block on our equal rights, equal opportunities, equal dignity, equal fraternity was, my lord, 377. By virtue of 377, our actions were subject to criminality. Because it was criminality, my lord, it could not be equal in all measures of the heterosexual group. Criminality is now gone. The unnatural part or the order of nature under 377 is now effaced from our statute book. And therefore, our rights being equal in all forms, which are, my lord, reflected from Puttu Swami, Navtej, my lord, the judgments of this court on the right to marry a person of your own choice, Shafeen and all that, which I will show. If our rights are identical as held by the state, then we want to enjoy the full panoply of our rights under 14, 15, 19 and 21 to lead a dignified life, not mere existence like your lordship said in Francis Corali Bulletin 40 years ago. To lead a life to our fullest extent with dignity, privacy in our home, and, my lord, without taint or stigma in public places. And therefore, we cherish and desire the same institution between two people as is available to the others, which is, my lord, the concept of marriage, the concept of family, because marriage and family is respected in our society. We don't, my lord, today, my lord, laws have now, my lord, progressed. In the Domestic Violence Act, even live-ins, my lord, are allowed. That is recognized by the court. Your lordship recognize it by even giving, my lord, property, money, inheritance, etc. So there is no reason why, once our rights are identical and same as held by your lordships, my lord. And that has been the development, my lord, in the US and other nations. I have made a one-page chart which I'll show to your lordship. Therefore, my lord, we seek a declaration. Because we have to be concrete. What do we want from the court? We seek a declaration that we have a right to, my lord, get married. That right, my lord, will be recognized by the state and would be registrable under the Special Marriage Act and other acts. But as far as I am concerned, my lord, my brief is to say that we want a declaration that we have a right to marriage and that marriage will be recognized by the state by virtue of the imprimatur of this court. And once that happens, the society will recognize us. Because even after 377, my lord, there is a stigma. If two people walk hand in hand in a park, my lord, or in a hotel or in a mall, they are still stigmatized in public. That stigma will only go after the imprimatur of this court that they are entitled to get married, and the state shall recognize it. And once the state recognizes it, it can also be registered. And that will be full and final assimilation of this minuscule group, my lord, into
Now, Mr. Rohde, assuming that you seek a declaration from the court
yes,
that queer people belonging to the queer community,
yes,
same-sex couples,
have a right to
have a right to marry, and therefore the state must recognize the
My
marriage
lord.
between these two. Now, what is the next step? Are you therefore saying that the Special Marriage Act already recognizes that right inherent in it?
Well,
a matter
my
of
lord,
an interpretative device or an
by an
interpretative
interpretive, my lord, I don't want it to be quashed or anything.
Right.
By an interpretative device, in one line, if I was to say, the provisions, my lord, of the Special Marriage Act made in 1954. Today, my lord, we are now 70 years down. There is a lot of evolution. As I said, my lord, live-ins, etc. have now come in. I want to say, my lord, that your lordships will broadly read spouse in place of man and women or husband and wife. And that is it. And if I may show, my lord, a classic example of the definition of marriage in Black's dictionary, which I will show to your lordship, in 1968, said, my lord, it's a union of a man and woman. But when the definition came in 2019, it says, my lord, a union of two persons. So concept of marriage has changed over last 100, 200 years. We had concepts of, my lord, group marriages. We had very different concepts. We had concepts of child marriage. We had concepts of, my lord, temporary marriages. We had concept that, my lord, prior to the Hindu Code Bill introduced after by Pandit Nehru, my lord, in 1950, a person could marry any number of times. That, my lord, also changed. Hindu Code Bill, my lord, was not accepted. There were a lot of protests to this new avatar of the Hindu Marriage Act. It was not accepted. And Dr. Ambedkar had to resign. Then came the evolution of Hindu Marriage Act. Now in Hindu Marriage Act itself, my lord, in 2005, the rights which were restricted of women, starting from the Women's Right to Inheritance Property Act in 1937, all that has now changed, my lord. And full rights are available in 2005. So, my lord, Constitution is a living document. The preamble says, my lord, equality, fraternity. And I will read passages of, my lord, the Chief Justice, my lord, judgment, my lord, in Navtej, in Puttaswamy, in Shafin, in Deepika, and Justice Kaul, my lord, also referring to it. This is the thread. If this is the thread of the Constitution, equality, fraternity, justice to all, today we are a part of the all. The only thing which was stumbling, my lord, was that criminality. That is now gone. If we are a part of all.
So really, your analysis is two-step. One, the declaration